question that I think most people ask, or maybe you guys in the appointments, is should I give my home to my children for $1? What would your response to that be?
Yep. And that's a good question. I think someone emailed in about this earlier because that's one that we get a lot. And that's a very common way, especially look 20, 30 years ago. You saw this a lot because, again, go back to the theme of long-term care planning, of what you have access to versus what's available. So if it's not in your hands, if it's not in your name, then it's not available. So with that in mind, the easier way, or the most accessible way, I suppose, to do that would be just to sign off the property, give it to your children, and hope that they don't kick you out. Well, before we get into the other risks there, if you do that, first of all, there is no guarantee that they won't kick you out. Now, of course, that doesn't apply to any of you, because everyone's children are perfect until they're not. And I've seen situations where, a child has gotten a new girlfriend who wants that house, and mom or dad is gone, and then that's going to be a court battle. And if it's just a deed to this person, no strings attached, it's their property. They can do what they want. So that's risk one. But then also let's think about the less malicious, because that's a really rare circumstance. I don't, and as many jokes as I make about people's children, most people wouldn't do that. I still see the good in humanity. But the other risks involved with transferring property to your children for $1, we summarize it as the 4 Ds. And think about it. So if you sign a deed saying, I give my house to my son, let's say, that becomes your son's asset. And the 4 Ds are death, disability, debt, or divorce. And life happens. And so while you've gotten your property out of your name to so that it's not in the mix for whatever might happen to you, now you've put it in another person's name, and your son is also human, and unexpected things happen to humans. So first D is death. So if your son were to die under these circumstances, you have a new landlord, because it goes through their will. Could be a spouse, could be their children, who knows? At that point, you've already given up the power, so you're kind of at the mercy of whoever inherits your house from your child there. Debt. And so in debt, think of debtors as creditors, just like anything else. So we talk about long-term care, things like that, people you owe money to. Well, if your children were to find themselves in debt, whether that's medical debt, credit card debt, gambling debt, not here to judge, just saying that it happens. If they owe somebody money, whoever that creditor is going to be looking at what assets they have. And in this scenario, your house is one of their assets, and it's not their primary residence because you're living there. So it's an additional investment property is the way it's viewed. And so that can run into issues. Then there's disability. So going in consistent with long-term care, if somebody becomes disabled, there's a lot of programs out there to help, but they have asset qualifications sometimes. So if the child that received the property were to have an accident and needs Medicaid, well, Medicaid has asset limits. So their overall net worth needs to be under a certain amount in order for them to qualify. So no matter how much they spend their cash down, if they own their own house and your house is again considered an investment property. So they'd be expected to get rid of it. And again, you have no say in the matter because you signed it away. And then the last one, of course, this would never happen to any of our families, but divorces. This could happen. Now, gifts are supposed to be off the table for a divorce, but that's the legal black letter law of a divorce situation. And divorces are tricky because people are tricky. And usually if you give a property to a married person, one of the first things that they're going to do for creditor reasons, or liability protection, their own planning, whatever the reason might be, is add their, if it's cash, put the cash into a joint account, or add their spouse to the deed. Well, at that point, it's no longer going to be separate property. So if they decide to divorce, you're living in a house that's now part of a divorce settlement. And that's already hard enough. Don't do that to yourself. So that's the 4 Ds. There's death, disability, debt, divorce. And so again, life is unexpected, and if I had to summarize the risk of just gifting the property to a child for $1, just know that you might be solving some of your own goals or the problems that you're trying to address, but there might be other problems lurking behind the curtain that you didn't think of when you transferred to the child. And so earlier I discussed the irrevocable trust, and that's one example of a way. So using a trust like that allows you to get the best of both worlds, where you can get the property out of your estate, but have it not enter the estate or the assets of another person. Think of it in simplest terms, it's held to the side until a specific time, which is most likely going to be your death. So it's held there. You get to say what happens to it when you die. You can live there. When life happens to your children, it's not going to be a part of it. You die, then it goes to them. And so that's much more straightforward way to do it. Just as an aside, while I'm thinking about it, because we did get an email earlier, and it was a good question from the person that asked it about how this works for tax purposes. Because anytime government changes, there's cheerleaders and there's naysayers. And the naysayers are here to scare you. And the cheerleaders are here to make sure you think everything's okay. And as always, the answer's in the middle somewhere. No, nobody's right. But I'll digress on that part. But you hear a lot about, what if they get away with the step up in basis for capital gains when somebody dies? And, right now, and the truth is that we can't really know what the tax landscape's going to look like when you die. If I knew exactly what the law was going to be when you're going to die, how you're going to die, I could make a absolutely perfect plan. But those things are up in the air. Right now, it is such that if a child inherits property from you that was in your name or in a type of trust that allows for this, then the basis in the property, meaning the amount that the government would say the property is worth when you bought it or received it, would step up. So that way, if your child were to receive or sell the property after you die, they don't pay capital gains tax. Now, there's been rumors that once Congress starts looking for money soon, that might change. But at this time right now, if you gift the property for $1, you're gifting your basis with it. So the evil that you're looking at in terms of what if they get rid of the step up in basis and I die, my child inherits my basis, you're more or less creating that issue right now if you gift it, because say you bought your property for 50 grand and now it's worth 180. If you gift it to them, and even if they wait till you die and they sell it for 180, there's going to be a $130,000 gain there, which under the current laws will be avoided if they're allowed to inherit the property. So I guess what I'm saying there is that under the laws right now, there's a lot of risks involved with gifting a property to a child. If that law were to change, you best bet that we're going to be doing seminars about it, because that would be a very, very, very big change. And if my opinion counts for much, it doesn't when it comes to politics. Nobody ever asks me anything before they do things. I think that one's very unlikely, or at least unlikely without some sort of income cap on it. Now, if you're making more than $1 million a year, there's probably another seminar on federal estate tax planning that you should be looking at. But most likely, I don't see that one being a big deal, because a lot of middle class families own homes. So right now, I think the best thing to do is plan for right now and make sure that the plan that you make has the flexibility and a knowledge professional, so that if things change in the road, your plan can adapt with it. So I think that's if you take anything from my long explanation there, I think it'd be that, and that let's plan for the laws right now, because we can't know what's going to happen, and then just have plan B if things change.
Yeah, and just to add on the whole transfer to a child, because I work in the crisis department, I actually see this a lot where, this was really the practice that attorneys used about 10, 15 years ago, transfer the property to the kid. They didn't really use irrevocable trust very much. And now I'm dealing with the kids who are disabled and they own a share in mom or dad's home. And it's a problem, like it's a mess. And so we have to deal with that. So, you know, we would strongly discourage anybody from ever doing that because you just don't know, like Landon said, what people are going to face. And your children might be healthy today, but you don't know what the future holds for them.